Thank you, interpreters. And the interpretation function is on. Please choose your language, and now we can get started. Thank you so much. Hi, everyone. Thanks for being with us today. My name is Sarah Green. I'm the Senior Policy Advisor for Sexual Health and Rights at American Jewish World Service. AJWS is a grant-making and advocacy organization. We fund grassroots organizations and social movements working on human rights issues in 16 countries. One of our areas of funding is the sexual health and rights of adolescent girls and young women, including preventing child early and forced marriage and unions. I'm going to moderate today's discussion, and I'll start now by setting the stage, then we'll turn to the researchers and advocates that you came here to listen to today. Our chat function is open. I can see you're already using it. And please be sure to put your questions for the panelists into the dedicated Q&A box. After we hear from the panel, we'll read out as many of your questions as we can so our panelists can answer them. We are also now putting a suggested hashtag and Twitter handles of our panelists in the chat in case you would like to use social media while this discussion is going on. So now, just to set the stage, I just wanted to acknowledge that how much the child marriage field, to speak generally, has evolved in the past several years. Increasingly, the field is shifting away from understanding the issue as one of just protecting children. Under that child protection frame, we saw girls as a wide category of females under the age of 18 that needed to be protected from child marriage until they turn 18. And then after that, there weren't children anymore. And so the issue stops registering as a concern. But the field has been increasingly shifting away from that framing to a framing that's more rooted in gender equality and the rights of women and girls. Under that new framing, child marriage is understood as a manifestation of gender inequality, one of many inequalities that girls and women face in their lifetime. Within this framing, success in preventing child marriage cannot just rest whether girls or women get married before or after 18, because we know that girls who get married after 18 can still experience the oppression, violence, and limited options and opportunities in their relationships and families. So in other words, instead of waiting till age 18 doesn't necessarily solve many of the structural drivers of child marriage, especially the patriarchal norms that lead society to devalue women and girls. So in this case, our vision of success is not age of marriage alone, but rather girls and women experiencing greater agency, choice, freedoms, and opportunities. This shift in framing and shift in perspective is very significant, and it calls on us to re-examine the assumptions we held and the approaches we used under the more protection frame. For example, what approaches were just focused on getting girls over the line to age 18, regardless of whether they had a better life? So in the field, we've now been focused on what we call gender transformative interventions, and these aim to address the structural drivers of child marriage. But despite this shift, there to date has been relatively little revisiting of our assumptions about the role of law in preventing child marriage and upholding girls' rights. And so while as advocates, we have long championed strong laws as a key component of preventing child marriage, there hasn't been a lot of research. There hasn't been a lot of research on law's impacts, do they work, or on their consequences more broadly. Are there downsides, and how can those be mitigated if there are? So that's what we're here to do today. We're here today with 3 researchers who have recently looked at the impacts of law in 3 places, in Mexico, Malawi, and India. And the research turns up some findings that might surprise you. And the findings create food for thought for governments who create laws and implement them, as well as advocates, those of us who are championing laws. And I think they bring up these questions of what kinds of laws help girls the most, what kinds of laws and what kinds of child marriage laws, and also what other laws will best support girls to choose if, when, and whom to marry, or with whom to otherwise have safe consensual relationships with. And then also what other things are needed outside of the law? What is the law's function, and also what are its limitations in this response to child marriage? So first, we'll hear the 3 research presentations, and then we'll hear from 2 young discussants who work in programming and advocacy on child marriage in India and Guatemala. And again, then we'll have time for audience questions, so please be putting those in the Q&A box as we go. So I'm going to start by introducing our first presentation. Our first presentation centers on Mexico, and it's interesting to start with a country in Latin America because that region has often not been front and center in the global discussions on child marriage. We generally focus on other regions, but the fact is there are many countries in the region that do have high rates of child marriage, as well as high rates of informal unions in which girls cohabitate often with an older man outside of marriage. And so for that, I'm going to introduce Maria Lombardi. She's assistant professor at Universidad Torquemada di Tella in Italy. She is going to be presenting a study called Can a Minimum Age of Marriage Laws Eradicate Child Marriage? Evidence from Mexico. And she's presenting that on behalf of herself and her fellow co-author, Cristina Bellez Obrero from the University of Anaheim in Germany. So with that, I'll turn it over to you, Maria. Thank you.
Thank you very much. So I'll be sharing my screen now. I hope you guys are seeing it correctly. Let me just make a brief disclaimer. I'm working in Argentina, not Italy. My name sounds Italian, but I'm actually from Latin America as well. So let me just start by saying that most countries actually set the minimum age of marriage at 18 or higher, as you can see in this map from 2013. But the thing is that most of these laws typically allow for exceptions. For example, girls can get married if they have the consent of their parents in many countries. And this makes child marriage legal in practice almost everywhere. And so a common proposal and what joins us together for this seminar is, well, perhaps we can end child marriage by increasing the minimum age of marriage, basically removing all of these exceptions that are in the law. And if these minimum age of marriage laws are enforced, then this should eradicate at least formal child marriage. What do I mean by formal marriages? Well, when girls go and get married to the civil registry under the law. The thing is that the overall impact of age of marriage laws depend on what the counterfactual is. So if we increase the age of marriage and we see a drop in formal unions, this drop could be offset by an equivalent increase in informal child marriages. And so the overall impact would be null. Furthermore, women in informal unions do not have the same legal benefits or social recognition as those that are legally married. So raising the minimum age of marriage could actually even be detrimental. However, laws can have an expressive function. What does this mean? They can tell us what is right and what is wrong and send a message to society. So increasing the age of marriage could contribute to changing social norms and could actually lead to a reduction not only in formal marriages, but also in informal unions. And so the study I'm going to talk about today looks at the impact of increasing the age of marriage in Mexico, and we look at the impacts on, of course, child marriage rates, but also the two most common and detrimental consequences of child marriage, which are school dropout and early motherhood. Let me tell you a bit about what these laws look like in Mexico before the reform we're going to study. Child marriage was basically legal in all 32 Mexican states, albeit with some restrictions. So girls needed to have the consent of their parents to get formally married, and they needed to be either 14 or 16 years old. This depended on the state. Some states also required the authorization of a judge or municipal mayor. It's a bit more complicated than this, but this just gives you a general idea of what the law looks like. At the end of 2014, the Federal Congress in Mexico sanctioned a law setting the minimum age of marriage at 18 and not allowing any exceptions. However, Mexico being a federal country, the competency of setting age of marriage belongs to the states. No? And so this law was not set in practice throughout the country. States were gradually reforming their civil and family codes to incorporate this change. And so this map that you see to the left of my slides shows you the states which adopted this age of marriage at 18 and the year in which it was adopted. And this is a key thing in order for us to be able to study the causal impact of raising the age of marriage, because we can exploit variation across states and over time. We use what is an extension of a differences in differences estimation strategy to empirically study the impact of raising the age of marriage. I'm not going to go into details because of the short time that I have on the methodological aspects, but if you're interested in it, I recommend that you go to our paper. We have a detailed discussion about this thing. So before I tell you our findings, let me just give you a brief overview of what child marriage looked like in Mexico before this reform. So you can see here in this graph on the x-axis, the year of birth of women. These are the cohorts who turned 18 before the reform was passed. And we can see that approximately a quarter of women in Mexico were either formally married or in an informal union before the age of 18. Child marriage is a big problem in Mexico. However, this picture is actually hiding some heterogeneities because some of these marriages are formal marriages where the couple goes to the civil registry and gets legally married, whereas others are informal unions. And you can see here the gray area is the share of these child marriages that are formal marriages, whereas the blue area are those that are informal unions. And you can see that the relative incidence of formal marriage has decreased, but it still accounts for a relevant portion of the child marriages that were going on right before the reform that we are studying. And one thing that I should note, and it's really important to understand the potential consequences of this law, is that only 1/3 of child marriages in Mexico are preceded by a pregnancy. So one might think that most of these child marriages are driven by girls who are having unprotected sex, they're getting pregnant, and then they're being forced into a marriage. This is not the case for the majority of the child marriages. The pregnancy comes later on. It's not a cause of the child marriage. So in order to study this question and look at the empirical impact, we rely on a wide variety of data sources. I don't have time to get into much detail about this, but let me just mention briefly that we have information on all of the marriages that take place in Mexico from marriage certificate microdata. And we also have information of all of the births that take place from birth registry microdata. This is key to being able to do this empirical analysis. So the first thing that we find, which is not surprising, is that once the age of marriage is raised to 18 in a state, there is an immediate and permanent reduction in formal child marriage rates, meaning the law is enforced. Girls are not allowed to get married and they effectively do not get formally married. And some back of the envelope calculations show that approximately 51,000 formal child marriages were averted due to this reform. However, when we focus on these two detrimental consequences of early unions, basically school dropouts and early motherhood, we do not find that raising the minimum age of marriage has any impact on them. And so we wonder, now I'm going back to what I was telling you at the beginning of my talk, we wonder if this is because girls substitute formal marriage for informal unions once these laws are set in place. And so we study this question and we find precisely that. Once the child marriage ban is in place, the share of girls who are 16 and 17 who are formally married slowly decreases and is completely counteracted by an increase in the share of girls who are in an informal union. And let me remind you that child marriage is composed by these two types of unions, formal marriage and informal union. So this counteracted rise in informal unions leaves the rate of child marriage unchanged. And one could think that this substitution of formal marriage for informal unions could have positive or negative impacts in the long run. On the one hand, informal unions are only legally recognized in Mexico if the couple has no impediments to get married. Once the age of marriage is raised to 18, informal unions of underage girls are not legally recognized. And women in informal unions might also have lower levels of spousal support, which could have negative consequences for them and for their children. However, on the other hand, for some girls, it might be advantageous to be in a union that is easier to terminate. Why do I mean this? For example, a child marriage in which there is domestic violence, having this be an informal union might have positive consequences if this means that the union is easier to terminate and the girl is more likely to leave this situation of violence. We are still trying to establish what are the long-run impacts of this reform. We do not have some results yet, but I'll keep you posted if we find something interesting. And let me just take my last minute to wrap up and give you the takeaway from my presentation. So let me just remind you that we find that raising the minimum age of marriage in Mexico reduces the rate of formal child marriages, but this reduction is counteracted by a rise in informal unions, leading to no impacts on overall child marriage rates, which are composed of formal and informal unions. And it's important to point out that in places where cohabitation of young couples is socially acceptable, Mexico is one of these places, minimum age of marriage laws are not effective at avoiding the negative consequences of early unions. So one could think, okay, let's make informal unions illegal as well. Well, one thing is that this is probably much harder to enforce. Banning informal unions requires much heavy presence of the state, which is really hard to implement. And this is also missing the fact that these girls are getting married for a particular cause. And in order to solve this problem, we need to understand why these girls are getting married in the first place. So there needs to be much more research in understanding the drivers of child marriage in every context. There might be reasons why girls are getting married in some places and not in others. We need local information on why this is going on. Is it lack of education, low empowerment, violence in the home? Once we understand the drivers of child marriage, then we can enact public policies that directly tackle the causes of marriage in that context. So let me finish with this. I'm sorry I took a bit too much time. Thank you very much.
Thank you so much for that, Maria. That was really clear. And sorry for mixing up your geography. It was actually the name of the university that threw me off since it's in Italian. I was convinced that must be where you were located. But nonetheless, your study is very clear and like a particularly crisp, clean, easy to understand findings, which are, that the law in Mexico, at least over the period of time with which you studied its impacts, essentially converted formal marriages to informal unions. So the marriage rates, when you look at them that way, didn't change. And some of the consequences of child marriage, which we are often working to prevent, such as girls' school dropout and adolescent pregnancy, also didn't go down. So that's a lot of food for thought as to the function and limitations of the law in this particular case. So thanks for sharing that study with us. I'm now going to turn our focus to Malawi, where researchers took a more community level look at the impacts of a national child marriage law. For that, we have with us Sajida Amin, a researcher at Population Council, and she is going to present Perceptions of Minimum Age of Marriage Laws and Their Enforcement, Qualitative Evidence from Malawi. Sajida, over to you. Thank you.
Thank you very much. I don't know if my video is muted, so if you can just enable the video, please, if you want to see my face. Good morning, good afternoon, good evening, everyone. I will talk about a study that is part of a multi-country study, research cum program intervention study that
Sajida, I'm sorry to interrupt. I used Zoom to ask you to start your video, and there you are. Fabulous. Thank you.
Great, thanks. This is a multi-country study. I led the research initiative on behalf of the Population Council, and there were implementing organizations, implementing programs. We started with some in-depth qualitative research to try and better understand the varying contexts where we were implementing interventions. As with many other child marriage initiatives in Malawi, the approach to preventing child marriage started with a host of formal laws that were implemented, and the Malawian government and society were very keen on implementing these laws, and they went into full force and effect. So unlike other contexts where child marriage is allowed with permission, with exceptions, Malawi had a very stringent enforcement of child marriage laws. And in our qualitative work, we try to understand other things in terms of drivers of child marriage. We're particularly interested in premarital pregnancy, as well as connections with schooling and other opportunities for work. And we didn't, but we found there was a very strong emphasis and interest in the approach to child marriage prevention that we saw in the communities. And we explored that further. It's written up in a paper that I will share momentarily in the chat. So here I'm just going to talk about kind of the main takeaways from that paper that has a lot of detail in terms of how perceptions of minimum age at marriage differ according to age group and by age in particular, and by kind of who we are talking about. So one of the most interesting insights we had from this qualitative work is both by talking to community-based organizations, but also adolescents and their parents and key informants in the community, is that CBOs leverage the law to prevent child marriage in very particular ways. And one of the ways in which they talk about it is to talk about marriage withdrawal. So this is where the process by which the communities are approaching the marriage is to leverage the marriage, but to then essentially nullify the marriage. So the statistics are intact. These girls are not registered in marriages. And basically the way the law is leveraged is by focusing a lot on the punitive aspects, and particularly in terms of the fines that are imposed on various actors if a child marriage is documented. So first of all, there is this whole emphasis on the event after the fact of it taking place. And then there is kind of a limiting of alternatives and options that families and communities and girls themselves have once these laws go into effect. Where we focused on kind of how different groups perceived these laws. And we found that in particular, we found one contrast quite useful. So adults and gatekeepers and implementers generally focused on the positive aspects of law. We withdrew a girl from child marriage. She went back to school. She completed her education, etc. Girls brought up more of the negatives. So even without talking about whether they wanted the marriage, which some of them clearly had, they mentioned the implications for the girls themselves, and very often the child or the pregnancy that was involved that had led to the marriage to begin with. So that started off us off on a whole chain of trying to understand to what extent premarital pregnancies were the driver. And at least in the qualitative kind of in discussions of the downsides of child marriage, it was very clear that concerns about who was responsible for, who was legally responsible for the child, who was economically responsible for the bringing of the child, all of those were important considerations as to why one might view this whole process of withdrawal negatively. So one immediate consequence of this whole process, of the whole emphasis on withdrawal, is that marriages are driven underground. So sort of like the Mexico case, where they have a more formal word for informal unions. Here it was basically that it's not a marriage and it's not a legally enforceable condition if there is a child involved, if there are certain rights that are associated with marriage that are now missing. So driving marriages underground, I think the particularities of it is something that that is very clearly recognized, particularly by young people, not so much by adults and implementers. And that's something that struck us as being very important. The other sort of major finding that we have is the whole approach to withdrawal doesn't help. It kind of focuses on the statistics, so focuses on prevalence, which obviously we care about, but only care about in terms of a marker for a fundamental process. In our work, we tried to shift the focus back from these from this focus on implementation of laws, and more on the drivers and on kind of creating conditions so that marriage is not seen as a viable alternative or as a preferred alternative by anyone, the community, the parents, the girls themselves. And these drivers are, of course, sort of all over the place. So in Malawi, education levels are quite high, so there's not much in terms of expanding the role of education, but work opportunities are very few. And those...
Très peu.
Sorry, I think there's something happening with the language interpretation. So anyway, that was kind of the fallout of this whole observation with withdrawal. I'll just spend a few minutes to say, I do want to recognize the expressive effects of the law. And in particular, what we saw in Malawi, which not just that it's setting certain standards about what it means to be a child, what it means to be an adult, what it means to provide informed consent, and kind of focusing on the whole issue of consent, which might have very positive implications. But this expressive effect, I feel like, is not adequately recognized and is often ignored by actors across the board. The other point that the expressive effect, the emphasis on age might have a positive effect if we choose to connect the dots with issues of consent, with issues of what is childhood, with issues of what is a valid informed consent, etc., within the context of marriage. And the other is, of course, when the whole emphasis on the process of enforcement becomes the driver of a program, you lose sight of what the real drivers of child marriage are, and you focus instead on a legalistic process, which is really just too little too late anyway. And so there is a need to kind of try and understand and connect the dots with what other contextual factors are driving child marriage. I think I'm out of time, so I will end there. Thank you very much.
Thank you so much, Sajida. That was great. I just want to reflect on some of the key things that you mentioned, which, I really focused on the mention you made of how girls' perception of how the withdrawals were working differed from the perception of the adults that were interviewed, and how girls didn't always see the withdrawals as beneficial to them in their lives for a number of reasons. And I just want to put the emphasis on how important it is to be consulting girls and doing research with girls and evaluations with girls on how child marriage interventions are working or not for them and what the impacts of them are. And I also just appreciate your reflection on what the law can do and how it can send a message and can send a signal. But the issue is so much more complex, and it's, I think kind of what you said, the law is sort of coming in after the fact, after so many other things have not been done to address, girls' options and empowerment. And so it can be important, but there are also limitations as to what it can do. So thank you for that example from Malawi. We are now going to turn to hear a research from India. We have with us Madhu Mehra. She is head of research at Partners for Law and Development, which is a legal resource group in India focused on justice for women. PLD has produced a series of reports on adolescent sexuality and child marriage. One report looks at why girls run away to elope in India. And another analyzes legal cases to see who is using India's child marriage laws in the courts and to what end. And a third report looks at how grassroots organizations are using the child marriage laws in their communities to prevent early marriages. These three rich pieces of research have been synthesized into one report called A Case for Differentiated Legal Responses to Child Early Forced Marriage and Unions, Lessons from India for a Global Audience. It includes considerations for advocates worldwide who are focused on child marriage wherever it occurs. So we are going to hear highlights from that report now. Thank you very much, and over to you, Madhu.
Thank you, Sarah. I can see many of the colleagues from India here, so I'm really sort of excited about the opportunity to bring all the three reports together and share the findings. Let me put out my PowerPoint. Yes. So my presentation is going to distill the main learnings and simplify the learnings as much as possible from the three studies. I will say that a fourth study is also underway, but we'll keep it to these three, which are quite comprehensive. Because the discussion on child marriage is so centered globally around law reform, and around what is called no exception laws, I think it would be very useful on a forum like this to share why differentiated legal responses are better suited for a very complex phenomenon, which we call as child early forced marriage and unions. So, yeah. Let me begin with what the context in India is. The contemporary context is one where the practice is prevalent within overlapping contexts of poverty, insecurity, patriarchal gender norms, and taboos related to female sexuality. So we don't find child marriage within middle-class families. It is something that is predominantly within contexts of poverty. This has been confirmed by the spike in child marriage after COVID-19 lockdown and economic distress. Panic marriages also follow riots. They also follow natural disasters. So sort of it signals the same framework within which it happens. It's a heterogeneous trend. It's complex. There is, of course, younger girls and older adolescents, but there's also self-arranged marriages, which are, some of which happen through elopements. There's arranged marriages, and there are marriages that are forced, whether it is by parents or by third parties. What we have in India, according to the national data, which is the National Family Health Survey, is predominantly early marriages in older adolescents rather than child marriage. And this is also within the context of poverty. Understandably, it's linked to lack of access to quality education, gendered nature of housework and caregiving, and and girls within marginalized communities and rural contexts are most vulnerable. Now, India has had, I think it's important to note, India has had a law for since 1929. And the current law that we have in force came into being in 2006. It has provisions that are very different from what are commonly discussed globally. So at a later point, I'd like to even talk about what kinds of provisions this law has and what kinds of outcomes it allows for. So, yeah. Now, if you move to the lessons from the 3 studies, I think the first would be that when we talk to frontline workers and peer leaders who have actively helped girls in avoiding a forced marriage or in exiting a forced marriage, what we hear again and again is that formal legal prosecution is impossible. It carries a lot of risks. It is inaccessible also because of the paperwork and the legality, but it's also inaccessible because it attracts a huge backlash, both for the frontline workers as well as for the girls. Yet they all agree that law is very necessary. What does the law do? It sets a minimum age of marriage, so girls know about it. Girls can negotiate, they can try to stop, they can try to, their aspirations are then sort of have a different threshold than what the community might set out for the girl. They also, having a law is an important tool that helps frontline workers secure the support of the administration, the child support system, and the police to carry out informal negotiations with the family and the community. And I think what is important is that we hear frontline workers always talk about working with all 3 systems, not with the police alone, because the stories that we heard were that when the police is approached immediately, the news of what the girl is planning gets leaked to her family, and the girl is likely to be disappeared and hastily married. So what do negotiations do, these informal negotiations? We find that very often, at least the aim is, whether or not it's successful, to negotiate long-term gains for girls. So ensure that her participation in youth groups continues to go to school, there's some follow-up, and so on. So the girls are not isolated. The goal is not merely to delay marriage. I think that's the important lesson here. Now we looked at, of course, there is a law. So who is using the law? And we looked at law, case law over a 10-year period. And what we found is that 2/3 of the prosecutions related to child marriage are carried out by parents of girls against self-arranged marriages of their daughters. And I think that tells us a lot about who has access to the law and why. Only 1/3 of the cases related to arranged marriages that had already broken down. And so they were in court I'll come to the reasons why they were in court. The law also appoints a child marriage prohibition officer, a CMPO, who is meant to implement the law, but the cases by a CMPO are negligible, and the cases against forced marriages are missing. So if you look at the reality of India, the larger chunk is, of course, arranged marriages by families. Whether or not they're forced is another issue, but they are arranged by families. But when you look at the case law, you get the impression that the largest chunk of underage marriages are of elopements. Now, when we talk to girls who had eloped in a qualitative study, what we found is a similarity in all the stories, a sort of a broad similarity, which is that there was poverty, lack of opportunities, girls dropping out early, not because of marriage, but because of housework, or because they were seen with a boy. That was enough of a reason. They eloped to avoid parental punishment. When their parents discover that they're in a relationship, they elope to escape a forced marriage, to escape violence in the home and the burden of housework. And this often results in a missing girl complaint, leading to criminal prosecution. Now, the prosecutions are definitely discriminatory in nature because they are against self-arranged marriages predominantly. And let's look at what is the disproportionate degree of discrimination that is manifested in the case law. You'll find that the child marriage law, the Prohibition of Child Marriage Act, is rarely used in such prosecutions. It's sometimes not used at all. So, and our case law work resonates with the National Crimes Record Bureau, which says for 2020 that there were 785 cases registered under the Child Marriage Act. And there were 24,745 cases registered as kidnapping with the intent to marry. So that's the difference. Now, if we understand the difference more, because often along with kidnapping, charges of statutory rape are also included. And the punishments for these charges go up to 10 years of rigorous imprisonment. And if you look at the civil remedies under the Child Marriage Act, which includes injunctions or declaring a marriage void because it's underage, they are just civil remedies. There is nil punishment. Now, there are some provisions within the Child Marriage Act, such as adults who have solemnized the marriage can be punished. That's for a maximum of 2 years, again, optional. Now, this point is being made not to emphasize that the child marriage law should also have draconian punishments. No, it shouldn't. But it's just to bring out the nature of impact of the two different kinds of prosecutions. Now, therefore, what is important is that for those of us who are engaged in law reform and dialogues and debates around it, we cannot talk about child marriage law without in the same breath talking about age of consent laws. Because in many of our country, adolescent sexuality, especially in India, is criminalized entirely. The age of consent is 18 years. This means that young girls cannot safely access sexual reproductive health information and services, and they cannot even legally be in a relationship. Forget about the social stigma, without wanting to be married to legitimize the relationship. Now, what is the outcome of a legal prosecution against self-arranged marriages? What we see is husbands get taken into custody immediately, girls go into shelter homes. Mostly the girls opt for shelter homes because they don't want to go back to their natal homes where they'll be punished. But the case law and the jurisprudence largely calls for case-to-case approach rather than a uniform, flat response. And this question has been taken up by the courts on more than one occasion, and the judicial position is one that this must require a case-by-case response. The courts tend to support the older girls who opt to stay married, and they have evolved since many decades now a principle called the age of discretion, where the girls, they consistently and unchangingly opt to stay within their marriage. So because they don't have the right to consent, the age of discretion principle is used to affirm their marriage. But remember, this is not a uniform approach by the courts. This is by and large what the courts tend to do. There are many cases where the courts have not adopted this view. Now, what specific provisions in the child marriage law allows for this nuance to come through, to minimize the discriminatory outcomes of the one-sided prosecution that we see? Firstly, the law treats child or underage marriages as voidable generally and void only in exceptional cases. So they are voidable and they can be either voided or they can be validated. The option is of doing that is there. The law gives the minor spouse the right to be heard in all court proceedings. Whether or not the court agrees with the minor is a different matter, but the minor has a right to be heard. And the law also gives the right to the minor spouse to repudiate the marriage within 2 years of attaining majority. So I think that's an important thing when the parents bring such cases to court. Very often when the courts uphold these marriages as valid, based on the principle of age of discretion, they use this clause that it is only the minor spouse who has the right to repudiate the marriage. But of course, courts do declare some marriages as void where the girl is too young or there are other facts that the court, whether agrees or doesn't agree with. Now, this is what the law is. And of course, this means that a lot of work needs to be done, that some amount of law reform is necessary to minimize the harm of the law, to activate the child protection machinery, and so on. But contrary to these kinds of proposals, the new proposals that are on the table are very different. In 2 of the states in India, child marriages have been made void ab initio. This term really means that all marriages are invalid on the basis of age alone, no exceptions. So that's a shift from the central law. A few other states have been considering this move. And more alarmingly, is at the central level, at the national level, there is a bill which is being considered as we speak to raise the minimum age of marriage of girls to 21 years, defining women and men to be children until 21 years for the purpose of marriage. If we are talking about reframing child marriage by centering empowerment and agency and capacities of young people, this is certainly a spanner, because if young men and women will be infantilized as far as their personal matters are concerned until 21 years, it is a cause of worry. So I think, so of course in India, we are, many of us who are part of this webinar today, who have tuned in, are very much part of the civil society coalition that are working to put out evidence and establish why raising the minimum age to 21 is going to harm. And our question to the global sort of stakeholders is, are we as vociferous about increasing the minimum age to 18 as to ensuring that the minimum age does not go beyond 18, because that's the universal standard in international law? Is that something that we would be as incensed and agitated about? Because that is a question that many countries might face in the coming years. Apart from that, there are a couple of other issues I want to put on the table for global advocacy. Is consider what factors besides age are necessary to advance empowering outcomes for girls in law when we talk about law reform. Consider the right of the girl to be heard in matters concerning the validity or invalidity of the marriage, especially if we are thinking of an empowerment approach where she is at least a participant in matters related to her life. Consider how the age of consent and other laws intersect with child marriage, how they cumulatively harm or criminalize adolescents and youth. Is that constructive? Does that advance empowerment? And I would like to hear of more studies, not just discussions on the legal provisions, but really studies on how the law is used. Who has the power to access its benefits? Who bears the harm? That's a discussion we must go to if we continue to agitate very strongly for strong legal provisions. And finally, You know, especially when we are confronted with a global formula of no exception laws, the question is what restorative justice responses and transformatory provisions we'd like to see in the law, or is it simply the validating or the invalidating of a marriage? And as some of the panelists have said before, to manage numbers, because of course numbers will be managed, but the lives of girls will not be changed. And most of us are committed to ensuring our engagement with child marriage is in order to impact and transform the lives of girls who are vulnerable, rather than manage the numbers and the prevalence figures. So with that, thank you very much. Look forward to the discussion.
That's great, Madhu. Thank you. It's tough to synthesize so much rich information and research and perspective into just a few minutes. And I think you did a great job of highlighting so many key dimensions. You know, I just want to be able to take away one key point, and that you pointed out, is the constraints and limitations young people face in India on being able to have a romantic and/or sexual relationship outside of marriage. And it's the fact that is so impossible to do socially, and how that motivates young people to enter into marriage, including underage. And also, you know, the point that you brought up of how other laws in the context, including the law to prevent child sexual abuse and laws setting the age of consensual sex, end up making it basically illegal for young people to have sex and have relationships, intimate relationships, and how that sort of is operating in tandem with the child marriage laws, which are in fact way more likely to be used against young people who are trying to be in relationships than they are used against adults forcing young people into marriages against their will. But in terms of constructive ways forward, I also appreciate the examples of how both in the judiciary, there can be nuance as to how laws are actually applied, and that judges can take into account the spouse's wishes and their maturity and things like that, and not just apply the law indiscriminately. And also, importantly, how grassroots organizations are able to use the laws in their communities as part of a bigger picture of giving girls more opportunities in their lives, and not just focusing on the impact of the law alone. So thank you very much for that. And I will put the reports, Madhu's reports, in the chat, and we will be sharing all of these research papers and presentations with all of you right after the webinar. So thank you for your interest in those. Since we have a half hour left, I want to turn now to our discussants. We are going to hear from two young advocates and practitioners who work with adolescent girls. So now I'm excited to welcome Gabriela Munoz. She is a leader in the network called Jóvenes Latidas, a network of young advocates for girls' rights in Latin America and the Caribbean. And she also works for the International Planned Parenthood Federation's Latin America office. Gabby is from Guatemala and is currently working in Colombia. I'm also excited to introduce Deepshika Ghosh, adolescent girls' rights specialist at the youth-led feminist organization, the YP Foundation in India. And Gabby and Deepshika, are you great? I see you're joining us on the screen. I'm going to turn this over to you, but before I leave, I just want to put a general question out there to you, and I want to keep it open-ended because we just really want to hear your reflections on what you just heard in terms of your takeaways from the research, but also, how this resonates with you in the context, both nationally and regionally, that you are both working in your work with girls and young people, in the advocacy and the programming that you do. And, tell us about the work that you're doing, and also what messages do you have for your fellow child marriage advocates based on the research that you heard today? So thank you very much. I'll turn it over to you both.
Muchas gracias, Sara. Y muchas gracias a todas las panelistas. Ha sido súper interesante escucharles. Pues sí, o sea, para Jóvenes Latidas ha sido un gusto participar en este espacio desde el inicio. Y como decías, pues nosotras somos una red de jóvenes latinoamericanas que trabajamos en varios países y nos unificamos inicialmente para taclear justamente esta problemática sobre matrimonios y uniones no deseadas. Y para responder un poco a tu pregunta sobre cómo se ve estas investigaciones en nuestro contexto, pues lo vemos muy, muy similar. O sea, en Latinoamérica, el tema de las uniones, el tema de la aplicación de la ley y la accesibilidad de las leyes son todo un tema que realmente nosotras vemos con preocupación. Y bueno, para como compartirles algunas de mis reflexiones, pues nosotras cuando analizamos el problema de los matrimonios y las uniones infantiles no deseadas, forzadas, pues vemos y partimos de la idea de que es un conjunto complejo de prácticas dañinas, ¿verdad? Y como tal debe abordarse con soluciones y programas integrales que además consideren esta complejidad y que se adapten a estos diferentes contextos, porque nosotras sabemos, como trabajamos desde la región y en diferentes países, conocemos que una solución no se aplica para todas nosotras. Y esto creo que es algo que las autoras dejaron muy claro. Y bueno, ¿a qué nos referimos nosotras también con soluciones integrales? ¿O qué implica? Pues implica trabajar con diferentes actores que afectan la vida de las niñas y las adolescentes en diferentes maneras. Y esto, por ejemplo, incluye a proveedores de servicios de salud sexual y reproductiva, que son muy importantes, a legisladores, a maestros y maestras, a padres y madres, a líderes comunitarios y religiosos, a hombres y a otros pares, ¿verdad? A otros jóvenes como nosotras. Y luego también significa tener programas que vean a largo plazo, que consideren los diferentes ciclos de vida de las niñas y las adolescentes y que inviertan de forma longitudinal en su educación, en su salud y en ampliar el campo de agencia, de manera que también podamos prevenir, por ejemplo, la violencia basada en género. Y es importante esto porque en todos estos elementos nosotros podemos encontrar las causas de los matrimonios y las uniones infantiles y tempranas y forzadas. Atender solo la legalidad no es suficiente y nosotras lo hemos visto y lo hemos experimentado. Y no puede ser el único motor de cambio significativo. Si reducimos la respuesta de los matrimonios y las uniones a las leyes, estaríamos asumiendo que este es el único elemento de la vida de las niñas que determina que sus matrimonios o sus uniones o sus relaciones son deseadas y que están libres de violencia. Y que determina también que ellas, o sea, tienen la autonomía, la total autonomía sobre sus cuerpos y sus vidas para tomar esas decisiones. Es importante que no subestimemos a los matrimonios y las uniones no deseadas y que realmente abordemos estas causas estructurales de las que estoy hablando y que además sostienen otras formas y otras expresiones de violencia que nosotras conocemos, ¿verdad? No solo los matrimonios. Creemos nosotras como red que es importante que las voces de las niñas y las adolescentes estén presentes y que estén incidiendo en la forma en la que se diseñan las políticas y las leyes para que éstas sean pertinentes y para que no causen más daño que bien. Y eso es algo que yo me llevo mucho y que espero que lo que nos escuchen también se lleven de la presentación de Madu y de María. Y que necesitamos asegurarnos que estos mecanismos que surjan de las leyes y las políticas sean accesibles para las jóvenes, que sepan cómo se usan, que sepan exactamente cómo funcionan y también que consideren la diversidad de jóvenes que existimos, ¿verdad?, en el mundo. Y bueno, también para contarles un poco, desde Jóvenes Latidas, nosotras nos enfocamos mucho en este tema de abordar las normas de género nocivas, las causas estructurales, como ya he mencionado, pero nos importa mucho también traer esta perspectiva ecológica y feminista a la mesa. Y es por eso que nosotros lideramos, por ejemplo, círculos de aprendizajes con niñas y adolescentes, abogamos y trabajamos con prestadores de servicio, líderes comunitarios y nacionales en cada uno de los países en donde estamos, y también para nosotros algo muy importante es trabajar en la colectivización de otras activistas juveniles por este tema, para luchar contra los matrimonios y las uniones infantiles y no deseadas. ¿Y cómo hacemos esto? Pues nosotros buscamos, digamos, hacer estas alianzas, no, digamos, para traer nuestra agenda y que se trabaje solo nuestra agenda, sino buscar esas intersecciones que existen entre diferentes temas, pero que definitivamente están asociadas a los matrimonios no deseados. Y porque vemos, ¿verdad?, que esa relación entre otros temas de la justicia de género y la igualdad de género con la problemática de los matrimonios. Y eso nos ha permitido hacer alianzas y asociaciones con actores que son muy valiosos para nosotros y que nos ha ampliado, digamos, nuestro campo de acción, que tienen efectos positivos también en nuestra incidencia. Pues, ¿cuál es mi llamado, creo, para otros activistas jóvenes o no jóvenes que nos pueden estar escuchando hoy? Que trabajemos en mensajes que reflejen esta complejidad de la que estamos hablando y que empujemos por una agenda interseccional que vaya más allá de la ley. Que la ley sea nuestro primer paso, pero que nuestra finalidad sea siempre esta autonomía y la agencia de las niñas y las jóvenes. Ahí lo dejo. ¿De Pishka?
Thank you, Gabriela, and thank you to all the panelists who spoke before us. This is it's really helpful to also contextualize what I wanted to share in the context of our work at the YP Foundation. So we at the YP Foundation, we are a youth-led organization, and we get to therefore work with some amazing young advocates. And I in particular get to work with some amazing adolescent girl leaders. When we are sort of interacting and working alongside adolescent girl leaders, we talk in detail about choice, about consent, about bodily autonomy, and we always draw from our own constitutional rights. That all of this finds reference and finds that kind of backing in the Constitution itself. However, I also wanted to share that, as we all know, that the institution of marriage has many rules, a lot of gendered expectations, and who we can marry and who who can get married, who one should get married to, is not only dependent on the legal age of marriage, especially in India. It is also dependent on different identity markers like gender. It's dependent on caste. It's dependent on religion, among other such identity markers. So it's interesting to it's interesting for all of us to talk about choice while also knowing that reality. Having said that, I think entering an institution like marriage also has its own perks, and different systems and structures which are put in place also help sell this illusion that this is a lucrative option, especially for women. So I'll talk about a few examples about different institutions enabling this kind of enabling marriage as entering into choosing to enter into an institution like marriage, rewarding, and anything other than that, punishing those behaviors. This was in the news recently about an IT company based in India, which was actually giving perks to their employees once they got married. There were monetary perks that one received upon getting married, and the institution went for the wellness of their employees. They went a step further to actually find alliances for them. And in the same breath, another news article was doing the rounds where a parent was holding their son and daughter-in-law accountable. They wanted them to have a child within the next year, or pay them a huge amount of money in return. So you could see that institutions apart from family, apart from the legal institutions, these institutions also enable us into believing that like marriage will have some form of perks, and it'll be some sort of a status. It'll if you follow the status quo, you will be rewarded. So but law is also in that same breath looked as an objective institution. It's almost extrapolated to being synonymous with justice. But I think it's really important for us to remember that even the implementers of law and other systems are also socialized into believing that all people are heterosexual, all people choose to marry, all people who choose to marry will reproduce, and any consensual entering into a consensual relationship, having sex that is only meant for reproduction. So when choosing to marry or not marry, marry at a certain age, or raise your voice around unjust practices and gendered experiences, especially for adolescent girls and young women, can be a very, very isolating experience. And the onus tends to fall on the individual who seems like a supposed anomaly. And accessing these legal systems could also be equally violating. The accessing such legal systems, like the question that was raised in the research itself, that who accesses these laws, who accesses these services, and what is that experience of people accessing such services, is something that we also really need to talk more about. And this gets even more complicated when we think from the lens of intersectional identities, how their experiences must differ. So we were talking about like what therefore can be our recommendations, what could like be the solution, what can be the next thing that we need to think about. But again, in the recent times, there was a news article in India that was doing the rounds about this particular judge in Madras High Court, who educated themselves on LGBTQI experiences, people's experiences and the history before deciding, or before sending out a judgment. Uh, this may seem like a very basic thing. However, it could actually start something new. This could actually set a precedent for people in positions of power to really educate themselves, and like hold themselves more accountable, and be more reflective. The other thing that we found when we are on the field is, as Madhu mentioned in the presentation itself, about the child marriage protection officer. Uh, I work in the Indian state of Jharkhand, where the state rules mention that the block development officer should be the child marriage protection officer. It's a dual responsibility. And oftentimes, the block development officers do not know that they have this additional responsibility, and what is it that they are supposed to do with it. So we think that it is important that we must hire, the state should actually make more opportunities for people to be in such positions, have more people, because this is an extremely important job that they're doing, and so that they're not completely burdened, and also go through that process of become part of workshops, have the conversation that we are having right now. In addition to that, like it's already been mentioned by everybody previously, that girls who choose to get married on their own, girls who arrange their own marriage, they tend to not it's not they don't get the easiest reception, and the law is also not an easy place for them to access, and they do not have the option to oftentimes go back to their natal home. There is that threat of violence there as well. So the shelter home really needs to be seen as not just an option for people who don't have space at home, because that would mean many of us. So we really need to see how many such services like shelter homes do we need to have in our country, and what kind of design of those kind of shelter homes should it be. It should not become like another jail for those the young people who are anyway struggling so much. So those were some of the things that we found while working with young people and adolescent girls, while working with organizations that work on and use the child marriage laws here in India, and the kind of struggles that each one of them face. So really centering the lived experiences of adolescent girls is something that we think should be the first thing that needs to come. That's the first thing that needs to be that lens with which we are analyzing the laws and the supporting systems around it. Thank you. Over to you, Sarah.
Thank you both so much, Gabby and Dipshika. Really rich reflections from the wealth of experience that you have in your context. And I won't even try to sum it up, but I appreciate, what you brought forward about what else is needed, about girls' access to education and health beyond child marriage laws in order to be able to build their lives, and just the complex social scenarios in which the law is intervening and how that needs to be understood, and girls' impressions and reflections of how that's impacting their lives needs to be a part of what we know and how we design and implement laws. I'm going to invite all the panelists to come back on the screen here with me so we can answer some of the audience questions that have been put into the Q&A box. So please, everyone, if you can turn your camera on, and Hannah, if you can bring us all into spotlight, that would be great. Thanks to the audience who have put in some questions, and I know we've answered some of the specific ones that have gone to some of the specific researchers. We were able to answer them directly in the chat. So I'm going to turn to some of, we have one specific question from Madhu that wasn't answered, and then we have some that are just like broader about the issues that we're talking about. So I think I'll first put the first question to Madhu about her research, and the question is there a correlation between the prosecutions and unions across caste and community lines?
In the qualitative study we did, there was, there were inter-community marriages involved. But that's because there's caste is so finely differentiated. It didn't even need to be very different. But it's hard to say that in the case law because you don't have so much detail. But what is also clear is that parents are not always interested in prosecuting till the very end. They might turn hostile midway. So then they're not supporting the prosecution anymore, which they started. Because maybe by then they've patched up with the parties or they've made peace or whatever. So it's not as if these, in the qualitative study, it's easier to track what's happening between the families, not so much in the case law. Yeah. I think choice marriages themselves are very fraught.
Thank you, Madhu. Thank you. And now I want to ask a more general question. I'm going to paraphrase some of the longer questions that have come through the chat, and I would invite the panelists to raise the hand if they would like to come in and answer. And one underlying question that has come in is, why are we still calling it child marriage? We have this large group of girls who are also adolescents, distinguishing between younger age groups and then girls who are 12 and older and girls who are then older teenagers. Why are we still calling it child marriage? And the participant is pointing out how that conflicts with also minimum age for access to many other things that young people need, including sexual and reproductive health information, CSE, age of consent. It's kind of a complex question that's kind of getting at a lot of what you have brought up about how, I think there's both a sort of, why are we calling it this and what do we mean by that? But also how the age limits and access to other things, how seeing all people as children under 18, how that is disrupting their access to services and other things they need. So Madhu, I don't know if you want to start us off with that reflecting on that?
Well, yes, I think, I mean, as Shireen's question was also what is older and what is child and early marriage. I think very generally speaking, when we're not talking about child marriage per se, we might even say 22 is early marriage. Or we might even have a discussion that is concerned about marriage being a compulsory institution for women. I think the discussion could be very interesting, but because we've inherited this child marriage framework, which is minimum age is 80, even within that, clearly the Child Rights Convention talks about adolescents and younger children. So I think in that, following that differentiation and the understanding of older and younger adolescents, it's easy to say within that 18 category, there is a child and there is an early. So, but clearly, I mean, even though adolescents need state protection and a lot of services, and they need to be treated differently from adults, what is clear is that they have agency and their capacities need to only be developed and cannot be ignored. So a law that says that your age is the final marker of validity or invalidity of the decisions you make is to my mind, it's going against the principle of evolving capacities of adolescents.
Thank you, Madhu.
That's from me.
Yeah, thank you. Does anyone else want to come in and add anything to that question?
I would maybe like to add something to what Madhu was saying, Sarah. Yeah, so I think thinking about this like as a legal framework in which you should prohibit these activities, it's a bit of a problematic issue, especially if we think about, as you were saying, adolescents, which they have rights to their autonomy and many other things. For example, in many Latin American countries, you can vote when you're 16 years old, no? So you're old enough to make these decisions, but not to decide who your partner is. I think the right way of thinking about this issue is just trying to ensure that girls are not forming these early unions because they don't have access to other rights which are essential to development, like education, a life without violence. I think that should be the main focus, no? Trying to ensure that when girls decide to form early unions, and of course, I'm not talking about something at 12 years old, that would be too young, but if it's like a 17-year-old girl who's deciding to form a couple, she should be doing that because she really wants to, and not because she just doesn't have any options for her development.
That's a really important point, Maria, and I think it comes up in all of the research we heard from today, even when you look more closely at the papers of how the absence of other supports and other opportunities in life can make marriage interesting to young people as sort of something of a last resort. Sajida.
Yeah, so I think we've heard several times, and there's a question or comment in the chat about the importance of alternatives. So, and I think we're hearing about that in various ways. But I also want to come back to something that sort of fundamentally bothers me about the focus on the law, which is that in the health sector, in clinical settings, we have a general principle of do no harm, and that somehow gets lost. And part of the harm, I think, is perpetrated, if I may, on both sides of the criticism, which is that we're unnecessarily investing time and resources in the minutiae of the law without and actually engaging a lot of resources in that without actually getting very far on it. And I think sort of the basic principle of do no harm, and it's not that complicated, and the solution is somewhere else. So let's not worry about the law so much.
Thank you, Sajida. I think that's a good seg into another question that we have that is going back to laws, where someone is asking, you know, in addition to these child marriage laws, do we have recommendations of what other kinds of laws need to be strengthened that would better promote girls' rights, such as education, sexual and reproductive health, etc. I guess, you know, we've talked, the panelists have mentioned, you know, the investments in these areas, but, you know, from a legal standpoint, how do you see the law being able to support access to those essential services for girls?
So if I may jump in again, we have in India a Right to Education Act, which covers only up to 14 years. So if you're talking about making the minimum age of marriage 21, and if you see girls dropping out of school because of marriage, then surely you should first be looking at strengthening the Right to Education Act. So I think there are all these other laws that need to be strengthened, and including welfare provisions and social security provisions for girls from marginalized and vulnerable groups. So that's really where I would say the solutions lie. Instead of creating a stronger policing environment where both the vigilantes within communities and the state starts, putting the legal machinery against very young people who they recognize are vulnerable, but they do nothing for them other than put them in shelter homes and lock them up. So I think that is absolutely, what is it's really alarming what should be happening and what is happening. So in the law space.
Thanks, Madhu. And you've said so eloquently before, how law is often seen as, or maybe developed and implemented as, a way for the state to, punish and control instead of having the state obliged towards its citizens. And I find that such an interesting, important lens through which we can be looking at the law. Is it there to be punitive, or is it there to be empowering and oblige the state to fulfill its human rights commitments to its citizens? So thank you for that. I also Gabby, I want to move to you, but I also think a comment that just came through the chat from Nicole is that, the laws can be relatively easy, so to speak, to pass, whether it's mustering the political will to get the resources towards other resources that young people need, like education, like healthcare, is a whole different matter. And so laws can look like a big achievement that might be easier to get on the books than the other resources that are needed. Gabby, your hand was raised. Did you want to come in?
No, yo creo que justo el comentario que leíste era mi aporte sobre realmente no solo enfocarnos, por ejemplo, en Guatemala se pasa una ley, pero realmente esa aplicación de ley no se traduce a política pública, no se traduce a inversión en jóvenes. Y entonces, como la importancia de no solo pasar la ley, sino ver que luego de eso pueda aplicarse de forma eficiente.
Thank you so much, Gabby. And here we are at time. And so what I would like to do, I would like to, if for our panelists who haven't spoken during the Q&A, is there one thing that you would like to leave the audience with just very quickly before we close today's session? Or open it up further. Anyone on the panel, is there something you would like that you feel that you haven't gotten to say and you would like to use the space now to do so?
I'd like to say something which is we haven't talked about and I think is increasingly important, which child marriage or forced marriages are often a response to insecurity. If you're going to resort to the law, I think one of the ways in which the law and its enforcement can work is to focus on issues of security. And sexual security in particular.
Para mí, si puedo entrar aquí, es solo hacer también un llamado a las personas que tienen inversión, en los gobiernos, a los donantes, que realmente no simplifiquemos este problema. O sea, lo que estamos hablando aquí son muchas cuestiones complejas y creo que es importante no solo visibilizar ese elemento, sino también invertir en las soluciones, en las voces de los movimientos de la niñez y la juventud que ya existen, que ya tienen propuestas integrales para abordar este tema y que tiene que ver con lo que estamos mencionando aquí. Entonces, creo que esa sería como mi última petición del día.
Thank you, Gabby.
I just wanted to add something. Yeah, so adding to and agreeing to everything that you have said, I think it's really important to just a lot of times I think we let go of a few things which sound like jibes or sound like comments. But off late, even now in the news, a lot of people in positions of power say things very casually. I think that's data for each one of us to see what is the intent and what is the sort of what each one of us or what our collective is sort of thinking about it. So like comments from judges, if we were just talking about law, or comments from other people in power, definitely something that must be brought into conversations and analyzed, and people should be made privy to all of that as soon as possible. And along with that, we've already understood that there's a huge connection between sexuality and sort of controlling sexuality. So bringing in those conversations as early as one can, not be worried about, like this is not the age, they're children, and this is adolescents, and this is young people, and therefore, these conversations should be kept away from a certain age demographic. It does not work in the long term, I feel. As early as we can, and we can have like a pleasure-centric sort of like not a fear-based introduction to comprehensive sexuality education would really, really go a long way. Yeah.
Well, thank you,
Yeah,
everyone.
I'd like to say, in addition to the points I've already made, is how do we make the state responsible for all the things it needs to deliver in terms of the creating opportunities and security and all the rest for young people from vulnerable communities, rather than treat the young people as individual offenders or their families as offenders. So I think we need to sort of create a discourse where the spotlight is on the state rather than the ones who are sort of having to just survive despite the structural inequalities or and in very harsh conditions.
Thank you so much, Madhu. And thanks to each one of you, Sajida, Madhu, Maria, and Dipshika and Gabby. Like, this has been a really rich discussion. I really appreciate all the work and the wisdom that you've brought to this. And I honestly feel like we could have done an all-day discussion with all of you, and it would have been extremely engaging. And so it just tells me that we need to convene again and continue this conversation. So much complexities were laid out, and there's always more to unpack. I think from the point of view of AJWS, this is such an important issue, and is really one that we need to explore further and in more depth, and with like open-minded, evidence-based dialogue among all of us who are working and investing in promoting girls' rights. So thank you to all the participants. Thanks for those who hung on as we went over time. Thanks for all your great questions and your participation in the chat. And immense thank you to the wonderful interpreters who are doing a great job. We had some wires crossing a little bit in the interpretation channels today, but thank you for your great work and for helping bring our messages to as wide a community as possible. We will follow up with everyone via email. You'll receive all the resources that we have, and we look forward to seeing you next time. So thank you. Goodbye.
Thank you.